Judge Hans Fabricius has dismissed former SARS head Tom Moyane's relief to interdict retired Judge Nugent from submitting his report to President Cyril Ramaphosa. Ramaphosa fired Moyane on November 1st after recommendations were made by Judge Nugent in an interim report from the SARS Commission looking into tax administration and governance issues at the institution.
It has failed to establish a prima facie right to set aside third respondent's ruling of 2 July 2018 or the President's acceptance of the SARS Commission's recommendation since, A, the Commission was lawfully established and acted within its terms of reference. 2, the interim report was lawfully issued. C, the President was empowered to remove applicant in terms of Section 6 of the SARS Act and did so lawfully and rationally. D, applicant's employment contact with SARS provided no impediment to the President's removal of him from office. And E, applicant was afforded an opportunity to be heard by both the Commission and the President, which he spurned with disdain. Paragraph 8. Applicant has alternative remedies available to safeguard his rights, such as they are, and does not require interim relief. 9. To do so, applicant will not suffer any irreparable harm if indeed any interim relief is refused. And 10. The balance of convenience overwhelmingly favors the refusal of the interim relief in order that the Commission complete its investigations and report its findings to the President, and that the President can proceed to appoint a new Commissioner to SARS. 11. The national interest far outweighs the narrow financial interest of applicant. It is my view that the application for interim relief, such as it is, must be dismissed, and is dismissed for all of the following reasons. 1. The application is not urgent, inasmuch as applicant has failed to show that the prima facie rights that he relies on are of such a nature that, if not protected by an interim order now, irreparable harm would result to them, which harm cannot be reasonably addressed in the future. 2. There is no cause of action pleaded that could sustain the grant of interdictory relief against the release of the final report of the third respondent. 3. Applicant has no legal interest in the content of the final report. 4. Interim relief was sought pending the determination of the Constitutional Court application, which has now been dismissed. In the absence of a proper pending application for final relief, interim relief cannot be granted. The quote, conversion unquote application prejudices the mentioned respondents. In appropriate cases, this court would, however, have the power to condone strict compliance with any particular rule. The decision of EKE, that is spelled E-K-E, supra, makes this clear. 5. The interim relief sought against the third respondent is unrelated to any of the final relief sought in the Constitutional Court application. It is unnecessary to preserve applicants' rights in the Constitutional Court application. 6. There is no affidavit by the second respondent before me.